Hey guys, I'm Mike Abernathy, Be Ambitious. I'm sitting here with Candice. Candice, can you introduce yourself?
Yes, I am attorney Candice Colucci with the Colucci Law Group. I am a property damage insurance attorney.
The first question I'd like to ask you, Miss Candice, is what do you do when there is a storm event? What is the first thing you should do?
Oh, what is the first thing that you should do after a storm event? Okay, so that's going to depend on where you are. So let's say that you actually stayed. So let's say we're going to use the example that you actually stayed in your house and the storm has just happened. So the very first thing that you're going to want to do if a storm has hit your property is take pictures. Take pictures and video. And video. I know we've always said take pictures, but I can tell you, since our firm, we litigate these cases all the time, that real life video has really made a difference because a lot of the storm causes water damage. And water damage is hard to see later on unless it does a discoloring to the property. And so, but a lot of times it would have been like almost raining in the house that happens, that comes through that roof. So taking pictures and taking video is extremely important to do. And if you have an insurance company, then you want to make sure that you file an insurance claim immediately. You want to call your insurance company and leave a message if they don't answer and let them know that you have experienced storm damage. You don't know the extent of the damage, but that you know that there is some type of damage. You want to file your claim, you want to take pictures, and you want to start mitigating your damages. So that is a very important concept, especially if you have an insurance claim, is that you start actually trying to stop that additional damage that'll happen if you don't do anything. So you want.
What aren't they supposed to do?
What aren't they supposed to do? So, and this is in regards to an insurance claim. So if after a storm, the things that you don't want to do after a storm is immediately do permanent repairs. So in every single time that you have got an insurance policy, what you don't realize that within that policy, there are a lot of provisions in there that you have agreed to. That you've said that in order for the insurance company to pay you for those damages you have, you've agreed to do certain things. And part of those agreements are that you've agreed to not complete permanent repairs without allowing the insurance company to inspect the damages, because they want to know what the damages are so they can determine what they believe that the value of those damages are. So we don't want you doing permanent repairs. We want you doing temporary repairs like tarping, drying out the water, those kind of things.
How important is it to take photographs for commercial property owners and property management companies before the storm?
That is extremely imperative. So if you think about it from going kind of looking at what the insurance companies love to do to get out of paying claims. They're our business. So one of the things that they love to say is that this is pre-existing damage. That is their go-to answer of why they're going to deny coverage. So in your insurance policy, it says, if this is pre-existing damage, we don't have to pay for it. So they love going, this is pre-existing damage, we're not going to pay for it. So one of the things that you can do to show that that damage was not there before the storm is to take those photos before a storm ever happens. And so you don't know if a storm is going to take place. So it's really good, especially for a commercial property where there is a lot of money on the line. And I would say for an association that has an obligation to each and every single one of its members and its owners, and a property management company who's managing that association, is that at least once a year, they're taking cursory photos of their property. So then they have those photos. So in the event that there is storm damage, they're able to have those pictures before to show that this damage wasn't there pre-existing. It happened due to that storm or that event.
So a lot of homeowners, business owners, commercial property owners, they don't really know how to read their paperwork. What's the best solution that you can give to a business owner or a homeowner, a property owner, on how to actually read their insurance paperwork?
Oh, that's a hard question because To just
I mean, we've got
tell you like
replacement
it
cost
is.
value, we've got depreciation, actual cash value. How do these all add up?
So a normal insurance policy is about 70 pages long, and it is written in the most confusing language purposely. The reason why they do that is so it is confusing for a person to understand. So then the insurance company can argue it to their advantage. So the answer to that is, how is it best interpreted? Is it's interpreted by an attorney who represents you. That's really the answer. The person who can best understand your policy is an attorney. And I could talk about it all day, that that one of the sad parts about sometimes when we come to an insurance claim, when we find out that someone thinks they have a certain amount of coverage or a certain type of coverage and they find out that they don't, it's because either an insurance agent has told them they had a certain type of coverage and they didn't, or they just thought that they had a certain type of coverage. And it is a normal occurrence, and it's understandable, because I can honestly tell you that most attorneys I know can't understand an insurance policy. And this is an area that I specialize in, and this is what I've made myself an expert in, so I can understand an insurance policy, but every single insurance policy is different. And so you have to really go line by line and really rip it apart. And it's very difficult. And there are times when I find myself in litigation. Our law firm is a litigation law firm. We take things to trial. We fight tooth and nail for things. So there are times when we are dealing with a massive insurance company and we're on one side and they're on the other, and we are fighting them over and over again about that language of what we believe it means and what they believe it means. So even two attorneys that are both skilled and knowledgeable are still fighting out about what it means. So that goes to show you that they are still fighting out about what it means that a normal person who's not an expert in the area cannot be tasked with understanding what it means.
So a lot of policies, I've had a lot of homeowners, they have these exclusions in their policy, and a storm hits and it's hailstorm. And I remember this old lady, her name was Daisy. She had an old dairy farm. Her husband was deceased. It was just her, and she had a cosmetic exclusion for metal. And she had thousands of metal buildings. And unfortunately, I wasn't able to help her out. I was brand new in the business, and we weren't able to overcome it. We didn't get a lawyer involved. She didn't want to get an attorney involved. What can you say? What is an exclusion, and what to look for and what not to look for in your policy?
Yeah. What I can say about exclusions is that majority of the time, they need to be scrutinized. If you are going to get an insurance policy and your agent is telling you that there are exclusions, the way that they're going to explain to you is they're going to tell you that there's an exclusion and that it's going to give you a discount on your premium. And I can tell you from experience that majority of the time that discount is never going to be worth it. So you really want to look at that exclusion and scrutinize it and understand what it's excluding. So a lot of times, the way that the exclusion is written is it's taking away a massive amount of your coverage that you think you have. It's taking it away, and it's giving you a little bit of a credit on your premium. And so when you have a loss like that, then you end up being screwed. So in that example, the sad part about that exclusion is, the sad part about that situation is that the good part about the case law is that case law looks at exclusions and says, listen, insurance company, you're going to write an exclusion. Exclusions are very, very, very much going to be scrutinized, and they're going to be looked at each and every single word. And if it's not clear, it's going to be used against the insurance company. So exclusions are actually always going to be helpful, if we have to argue it, to the insured. And an exclusion like a cosmetic exclusion is one of the most ridiculous exclusions I have ever seen, because at the end of the day, almost all damage is cosmetic to a degree. Physically, looking at something physically, it's been damaged. So if a storm comes through, there's a cosmetic damage there. It physically has been damaged. So in this instance where the insurance company has denied it and said it's cosmetic, we could have come back and said, no, it's not cosmetic. Here's how it's functionally not going to work the same. Here's how there has been a reduction in the life value of this roof, which now makes it to where she now has an actual discernible loss, a loss to the property that she should be made whole again for. And so that's how you would have potentially worked around that exclusion. But exclusions are very, very scary. So you really want to make sure that when an agent is saying, hey, there's an exclusion and you can get this much off for it, you really want to look at those and make sure that they're not something that you could potentially down the line need.
You know, we have a commercial client right now that we're running into a problem where we need to replace the roof, but they don't have ordinance and law. They don't have the coverage in their policy. So what advice would you give to somebody that has an exclusion for ordinance and law in their policy? How do you get them back whole?
So the very first thing about law and ordinance in the state of Florida, and this is a nice little caveat in the law. And so if you knew the political process of what happens when an insurance company is trying to change their policies, they have to go through the state and get approval, because the state has made it very clear that they don't trust the insurance companies. Majority of them are private companies, but the insurance company says, no, the states say, no, we have an overwhelming responsibility to protect the people. So we are going to step in and say, if you want to do something like change your policy, we need to see it and review that change before it happens, because we don't trust you, is really what they're saying. And so looking at ordinance and law, it's one of those things in the insurance policies that they have said, if you're going to exclude it, if you're going to write a policy and have somebody sign that policy where you've excluded their law and ordinance, you have to have them sign a specific document. It's a one-page document where they have knowingly waived their right to law and ordinance. And it is a one-page document that's additional. And I will tell you that there is a lot of time. So the first thing we do in this situation is we demand from the insurance company that document from the underwriting agent. And you'd be surprised how often it doesn't exist. And if it doesn't exist, then that client automatically gets 25% law and ordinance for free.
What kind of information can you give us about managed repair programs? You know, we run into a lot of times where I've got a commercial client, they're like, hey, it might come out, and then they're like, oh, well, our insurance guy's got a guy that's going to do it way cheaper. What can you say? They're like, oh, we're on the management repo program.
Yes. Okay. So insurance companies in Florida and in other states, there are some of the insurance policies that have something we call a managed repair program, and they also call it an option to repair. So what that is that it is a certain type of policy where they have told you they've given you a credit, and I will tell you the credit is usually $50 to $100. It is not worth it. Not worth it. Let's start there. It's not worth it. And what they're doing is that instead of them writing you a check for after you have a loss, instead of them writing you a check for the amount of money that they think your loss is, they say, we're not going to write you a check. We have friends that are contractors that we're going to have come out to your property, and we're going to have them do the repair. So if you can think about it from a business perspective, that's what I kind of like to do. I kind of like to not say, hey, let me tell you my opinion and let me tell you based on what I've seen. Let me just tell you from a business perspective, and you have to think about it from that perspective. The insurance companies are in the business of making money. And so how they do that in that situation is they work with contractors who are going to give them bulk rates on everything. So they're saying, hey, Mr. Contractor, I'm going to give you a bunch of work. So I'm expecting that work to be pennies on the dollar. But also, here's the best thing. You also don't have to get work from any other source. So you don't have to have reviews. It doesn't matter if you respect the client. And it doesn't matter if you don't do what the client wants. And guess what? We also, as the insurance company, gets to decide the scope of work and what actual cabinets are going to go in there, flooring's going to go in there. So you also take away the insured's right to choose those things. So that situation in and of itself becomes extremely abusive and unfair most of the time to the insured. So the program in of itself, from several different perspectives, becomes a disaster to most of the clients that I've seen it ever done with. So I always say, if you can, and if you ever know that's an option in your policy, and you're about to get a policy that has that, get another policy. Like I just got a renewal on my policy, and the policy that they offered me for my agent was a policy that had that program. And the way that it works is that the insurance company, majority of the time, after you have the loss, they have 30 days to decide if they want to invoke that right. And so they'll either invoke it or not. And so I said, absolutely not. I do not want a policy that has that option at all, because if I have a loss, I want to be able to have a check written to me and potentially my mortgage company, and I want to decide what contractor I hire. I want to decide how I want the work done, what type of work I want done. I want to decide the schedule that it happens. I want to decide in draws how I'm giving the money out. If the contractor doesn't show up, I want to make those decisions. I do not want to have to go through my insurance company for it.
So, I run into a lot of these commercial clients, the insurance company tells them to get 3 estimates. Why does the insurance company tell homeowners and business owners to get 3 estimates? And do they have to get 3 estimates? Is that something that's written into the policy?
So the insurance company wants you to get 3 estimates for several different reasons. One is, sometimes the insurance company's game is to run the insureds ragged and to just drain them out through the process to where they're willing to take whatever amount of money is being offered to them. So that's part of that process. It is very difficult, especially after, let's say, a hurricane, where there are a lot of people in one area who need help. And so trying to get 3 estimates from a contractor is very difficult to do. So then it becomes difficult to even get those. So then the insurance company now doesn't even have to make any payments, because they've said, hey, I've asked you for 3 estimates and you haven't given them yet. So that also allows the insurance company to hold on to money longer. So that's one of the reasons. The other reason that they do it sometimes is in an effort to pay the least. So they're going to go, give me 3 estimates and we're going to pay the least amount. I have never seen them say, give me 3 estimates, and when you give them, they go, we're going to pay the highest one that there is. Absolutely not. And to answer the other question, do you have to? Absolutely not. Nothing in the policies that I have ever seen says you need to give them 3 estimates. You have no obligation to do that. If an insurance company says, I want 3 estimates, and I have clients who call me all the time, or potential clients who call me and they say that that's what they're asking for, I say you need to tell them back, absolutely not. I have sent you an estimate from a contractor. And I start by saying, is it a contractor you trust? If it's a contractor that you trust, then, and that's the estimate that you feel comfortable going with, that's great. Do I think it's a good idea as a prudent property owner to get more than 1 estimate? Absolutely. But is it you're capable to do it all the time? No. And is it a requirement of your insurance company? Absolutely not. You do not have to do that. So you can tell the insurance company, I'm not getting more than 1 estimate. This is the estimate that I have, and I believe that it's reasonable. And if the insurance company doesn't believe that it's reasonable, they need to explain to you why they don't think it's reasonable, why they're not going to pay it.
So the only time, just to clarify this for everybody, the only time that they would be required to get 3 estimates is, you're saying it would have to be written into their policy as like an exclusion or something like that, a provision?
It would be a provision. It would technically be a provision in their policy. It says you need to get 3.
So what happens when you disagree with the insurance company over the price or the scope of work? What is the process when you disagree with your insurance company?
Okay, so let's walk through the process of an insurance claim. So you have an insurance claim. So a storm comes through, you file an insurance claim. The very first thing that happens is the insurance company comes out. Their plan at the very beginning is to be your friend. It is a tactic that they do. They have learned from the best probably advisors that the more somebody trusts you, the more they're going to trust the information that you give them later on. So down the line, when the insurance company starts to be facetious, lies, fraud, all the stuff that they will do sometimes down the road, you trust it. So the best thing they'll do is they'll usually start very nice at the beginning, and they'll have you come out. They'll come out and they'll bring an adjuster out, and that adjuster is going to come out and they're going to assess your damages and create an estimate of damages that they believe your damages are. And most of the time that I always see, that number is extremely low. So when you get that number and you usually try to go find a contractor who will do the work for that number, it is very difficult to find one, and that's usually when somebody realizes that creates that dispute over what we call the scope or the price of what you've been given from the insurance company. So what we love about what we do on a day-to-day basis, and the contractors that are in this business, the mitigation companies that are in this business, the mold companies, the public adjusters, the attorneys, what we all love is when people know we exist, and then we all work together to tell a homeowner that what the insurance company told you when they told you that they're not giving you any more money and that was enough money is not true, and that you have the right to dispute that. And in Florida specifically, those rights are extremely strong. They are so strong in Florida that Florida says if you have to dispute the payout from your insurance company and you're forced to file a lawsuit against your insurance company, and they end up having to pay you a single dollar over what they already paid you, then by law, they have to also pay your attorney's fees additionally. So then you're not out any more additional money. So that's how much you have your right to dispute that amount of money. The insurance company will not let you know that off the top. They're not going to say, hey, you can hire a public adjuster who will help you dispute that, or you can hire an attorney who will help you dispute that, or a contractor who will help you understand that whole entire process. So those are some of your options that you can do. But understanding you have those options is really where we're at. I think the number right now is like out of all the claims that are filed, it's like between 2.5 or 5% of the claims somebody will get representation. So we're looking at somewhere in the 90-something% of claims that are paid out, they never get representation. And I can tell you from my experience, it's not because they're all getting paid out.
So what you're saying is if you do have to file a lawsuit, a business owner or a homeowner, and you win, the attorney's fees are paid for in the state of Florida. Do they pay 2 or 3 times the amount of damages, or is it just the scope of loss and the money that they pay and your fees, or how exactly does that work?
In Florida, on a regular breach of contract, so if they have underpaid your claim and you have to hire an attorney and the attorney files a lawsuit, and the law says that if they pay a single dollar more, then the insurance company could be forced to pay reasonable amount of money towards your attorney's fees. So what ends up happening is they end up having to pay every single dollar towards indemnity, is what we call it. That means the money you need for the repairs, and then also have to pay some money towards attorney's fees. So it's all ends up being kind of determined within the court system of what those reasonable amount of attorney's fees are and what your indemnity amount is, but you're getting some money towards it. Now, if it's proven that it's bad faith, which is a whole different type of lawsuit, so that's showing that there's more egregious behavior, it's not just a normal breach of contract, there's more of kind of an intentional effort to really keep the money from you, there's more violations of laws and statutes that are happening there, then that's when we're talking about additional damages on top of that.
What about appraisal? What can you say to the people about appraisal? What is appraisal? When's the right time for appraisal? And in the state of Florida, is appraisal binding?
So appraisal is an alternative dispute resolution. And so what that means is it's an alternative option instead of going to a lawsuit. And within most insurance policies, they have a provision written in there that says that in the event that you and the insurance company disagree, that one of you can demand appraisal, and if they demand appraisal, then you have to go to appraisal. And appraisal is this process where the insured hires an appraiser, And that appraiser is someone who is qualified to determine your amount of damages, to write an estimate of your damages, and is qualified to argue about why those are damages, or how are they attributed to the actual cause of loss. And then the insurance company hires an appraiser, who's also obviously qualified to determine the amount of loss. And those two appraisers go back and forth over those numbers. If they cannot agree on a number, then they hire an umpire. They bring in an umpire who's another party, who's usually the same qualifications as that of the appraiser. Is the same qualifications. He's qualified to determine damages, and then the umpire also comes out, looks at the property, determines what the damages are, and then what it takes is it takes two people to agree on the damages. So at the very beginning, if those two appraisers agreed on that number, then it was done. But if they don't agree and they're like, no, we can't agree, we're still off, and they bring in that third party, that umpire, then it only takes two people to agree. So if the umpire and the appraiser for the insurance company agree, then that number is binding, it's done. And if the umpire and your appraiser agree, then that number is done and we're good to go. So there is a risk with appraisal. And the risk is that if the umpire agrees with the appraiser for the insurance company that the insurance company hired, then it's a binding amount that may not be every single dollar that you had wanted. There are times that the appraisal process is beneficial, and there are times when you don't have a choice. So if the insurance company demands appraisal, which sometimes they do, you don't have a choice. You have to go, and it's binding. You don't get to go to a lawsuit. When a lawsuit guarantees that you have more control over the process. If you're in a lawsuit, you're going to be able to fight for every single dollar you want, and you have more control. And if you don't want to settle, then you can keep on fighting all the way to trial, and you can ask for every single dollar you need to rebuild, and you have more control over that process, and a more likelihood of getting every single dollar you need. And the appraisal process does have that risk. Now, the benefits of the appraisal process is you have more of control over the timing of it. It is a faster process sometimes. So if you decide, I'm going to go to appraisal, a lot of times that process can be 60 to 90 days process from start to finish. It can be longer. I will tell you, especially with COVID, we have seen them go 9 months, a year, an appraisal process, especially if something happens to one of the appraisers, something happens to them, they get sick with like what we have with COVID, they've gotten sick, the insurance company kind of goes MIA, and then we start to fight about that. So we have seen it go a year, we've seen it go a little bit longer than that. We've had to bring in engineers and all kinds of different experts, so it can be a long process. But majority of the time it's a small process. And so that's a benefit of it. The other benefit of the appraisal is there are situations when some people have a loss and they decide that they're going to sell their house as is, and that happens sometimes. And in that situation, you still can reclaim the rights to your insurance claim. And that is perfect for appraisal because you don't need every single dollar. So you're like, well, I've already sold the house. I don't need every dollar to rebuild because I've already sold it as is. And so whatever I can get now is just, is money that I can just take with me on with my life. So appraisal process then works perfectly fine. So it has its benefits, but that it also has its risks, but so does litigation at the end of the day.
What happens, Candice, in this situation where a contractor, you have a signed contract with the contractor and the contractor's not performing? Is there a statute that protects a business owner or a homeowner? Like, what do they do if they're not doing any work? Is there a certain amount of days? How can we help these people where contractors aren't doing what they said they were going to do?
There is a remedy. So the state of Florida actually just redid a statute. It's under 489, and they put some limitations on what a contractor has to do time limit wise. And so what it looks at is it says that after a contractor receives a certain amount of money up front, so a lot of times they get a deposit. So once they receive a deposit, they have 30 days to pull a permit. So that's the very first time limit they have. So they have to perform. They have to apply for the permit within 30 days. They have to apply for the permit. Then after they receive the permit, they have to begin work within 90 days. and then they can never stop work for more than a 90-day period. So it's a little complicated in the way they kind of break it down. So if any of those things take place, so if they don't pull the permit within 30 days, or if they don't start work within 90 days after pulling their permit, or if they ever just go MIA and don't perform work for 90 days straight, then a property owner has to send a demand letter to the contractor demanding them to do a certain thing. And the statute's very, very clear on how that demand letter has to be written, how it has to be addressed, and what you're asking for. And the redoing of that statute was genius, brilliant. The way they did it is amazing. What it did was it allowed that if you send this demand letter, so if the property owner sends a demand letter and says, Mr. Contractor, you have not pulled the permits within 30 days, then they can demand their money back. They can say, I want my deposit back right now. And if the contractor does not give them the money back within 30 days, they can send all of that documentation to the local police department and state attorney, and it actually becomes a crime. It becomes theft. Yeah.
Wow.
Yeah, it's madness.
That is good.
And it was really rewritten. It used to not actually be that way. And then also they have the right, so let's say like later on in the process, after the contractor has been doing work and then just goes MIA for 90 days, then the property owner can send that demand letter as long as it's being addressed right and done the right way, which is why you really have to, this is really where you would look to a lawyer, where I would say a lawyer is important because you want to make sure you're doing it right by the statute, because it's very specific. If you don't follow the statute, then you're not going to get that remedy of potentially being able to go after them criminally. And so let's say they stop performing work and you send the demand, you can send the demand that just says that I'm demanding you to continue work. And if they don't continue work, then once again, it's considered theft of the money that they have in their possession. And you can also demand the return of the money that they have not done yet on the property. So you have a lot of remedies when we have contractors that, unfortunately, it just has been an issue, and where there are fantastic contractors out there, but there has been contractors that just abscond with money. They got people who come and go, so then they just don't show back up to do the work, or they get a chunk of money from the client up front, and then life happens, and then they spend the money in another place and they misappropriate the money. That's a huge issue with some of the contracting companies. So it does give them remedies. So know that if you cannot get a hold of your contractor and you've given them money and they have not done that work, you do have remedies.
What can you tell us about mold claims in the state of Florida?
Oh, mold claims in the state of Florida. So mold is the concept of mold, which I know way more about mold than I ever wanted to know. And now I find myself always stressed out about if I smell mold, because once you learn how dangerous mold is at certain levels. So on a day-to-day basis, there is a level of mold just that exists in life. It exists in your home all the time. It is in your insulation, in your roof. It happens in your house, in your carpet. It's just in there. Now, the issue is when it gets to a certain level, and there are companies who test that mold. And when it gets to the high levels, it's going to be the result of where there is some type of moisture buildup and humidity. And so that's going to come from leaking that's happening inside the house. And so it's going to come from usually an AC that's leaking, piping leaking, roofing leaking. And so I always say that you may not be sure if you have mold, but it's when you have that musty smell, when you are waking up with a dry throat, or your eyes are watering, those are going to be those tall tale signs that you have mold. Sometimes obvious, and sometimes it's those little things. And it can get really scary if you don't take care of it. And so there are mold companies you can call, and you can have them come out, and they will take air samples. They send them off, and they get an actual result that tells them how much actually and the microbials hold, scientific
to determine. Would the insurance company pay for that? I mean, because
depends. Yep.
They're not going to know if they have mold. I mean, they're not mold experts, so they hire this company that's going to cost several thousands of dollars. Like, who's going to pay for that?
Yeah. So most people have mold coverage. I will tell you, in the state of Florida, State Farm, most policies for State Farm don't have mold coverage, so I'd be very careful. But a lot of the policies do have mold coverage. The problem with mold sometimes is figuring out where it's coming from and if that is covered. So let's just say that it's coming from a leak that you've been ignoring, and that has created mold that could potentially be denied because it could be considered that it's just negligent, and that is an exclusion in your policy. So you do have, most people have coverage for mold. It is limited. It's most of the time limited to $10,000 if it's a commercial. I mean, if it's a residential policy, commercials policies usually have more, but mold is definitely limited. And so you definitely want to be on high alert for it and figure out where it's coming from, because most of the time it's coming.
So how important is it to get wet materials out before the mold happens? So there's a storm, a hurricane, you've got water coming in, you've got wet insulation, the drywall, maybe the carpet's wet. How important is it to get that wet stuff out of your home? What do you do?
It is imperative when it comes to your insurance claim, number one, and it is imperative for the livelihood of your house. And so for your insurance claim, you have a duty to mitigate your damages, 100%. It is written in there, and if you do not mitigate your damages, which is to do whatever's reasonable for you to make those damages less, and the wet material that happens after, like a storm where the water comes in, if it is not dried out or removed, so if the water comes in and it gets all of the drywall, if it's not dried out with certain machines or removed if it cannot be dried out, and that's what there's actually called, their water remediation companies that will figure that out. There's special companies that do it. If you don't remove it or dry it out the right way, it will turn into mold. And then it creates additional damages that becomes very, very expensive. And the insurance company can, if you don't mitigate your damages, then they can deny those additional damages. So it's extremely important to potentially remove that water-soaked material if need be. And if it can be dried out, which is what the experts figured out, sometimes it can be, sometimes if it can't be, then it has to be removed.
So what you're saying, when you mitigate the property, so if somebody had a leaky roof and they're aware that it's leaking, they have to put some type of tarp or some type of covering over it, some type of emergency repair?
Yep.
Or you're saying that the insurance company might not pay for the damages on the inside?
Yes. So that's a great example. So tarping is the number one mitigation concept that we use all the time, because that's usually what we see most common. And so if you have a storm and you have got water that's coming in through the roof and you see it. Now, sometimes there's water that comes in through the roof that you do not see. And if you see the water coming through the roof, you have got to mitigate those damages by calling your insurance company and letting them know that there's water coming through the roof and filing an insurance claim. That has to happen, number one. And you need to call a contractor and have them come out and tarp it, or have somebody, there's other companies that will tarp, or call the insurance company and tell them that you need to have you talk to them about helping you have somebody come out and tarp it. If you do not mitigate those damages in some form or fashion, then they can deny the additional damage that happens because your failure to mitigate.
So we're talking about big condo associations or maybe a hotel, and let's say that the power goes out. Does the carrier owe for power to be brought to the condo, or maybe even a homeowner? You know, they lose their electricity. Does the homeowner, does the carrier owe for a generator so they can keep the lights on, or how does that all work?
Well, it's a little bit more of a complicated answer. So the way that works is, the question is, we always start with, it all depends on your policy. Every single answer I've ever given, it really goes down to depends on your policy. But it also depends on what caused the power outage. So if the power outage was due to direct damage on your property from the event. So if a hurricane actually hits your property and that causes the power outage, then that's normally going to be covered. But there are instances, and then if you get a generator and you have to bring in a generator, then yes, the generator is going to be those additional living expenses that you have most people have a part in their coverage for it, and that would be one of those expenses that they're going to majority of the time be responsible for covering. But there are times, and this becomes a big issue, and this is why this is very important, where like a lot of times in commercial policies, there are exclusions for electrical outage. It is a big common place for insurance companies to save a boatload of money for them to put exclusions for electrical outage. So during a hurricane, you may have gotten some property damage, but the reason why the electricity went out is because down the street, the power line or the transformer got hit, and that's what caused the power to go out in your property. Well, that's not actual direct damage to your property that caused the power outage. So that could actually not be covered. So that's why it's really careful in those instances, especially in commercial policies, to look and see what caused the power outage, what's in my policy, before potentially you get the mitigation efforts or whatever you may do, because it may not be covered.
So what happens when a business owner, the storm happens, you're doing the reconstruction, and we have to close the business down? Let's say it's a restaurant or maybe a hotel, and they lose money. Is there any way that they can recoup any of the money that they lose because of the storm?
So those are usually under business loss expenses. And so that's a specific different area of coverage. And that's going to be all about how exactly it's written in your coverage. And I can tell you, going through several storms and dealing with this for years, it's a very convoluted area. There are times and that, yes, your loss of income is recoverable, but it's usually capped on not just the amount, but a lot of times it's capped on the amount of time that they will reimburse you for. Okay. So even though maybe your let's say that your remodel is going to take, a year or a year and a half. Sometimes there's policies that say we're only going to give you business loss expenses for 6 months. So you really want to look at that too and see how long it is for and what the amount's for.
Okay. And then what can you explain to people what consequential physical damage is, first off? And I want to give a couple examples of what's happened to me in the past. I've had clients where we've actually changed the roof to wall stucco, or the flashing that goes behind the stucco. Mm-hmm. We've damaged the stucco, and then the insurance company, they don't want to pay for it, but we have to because the International Building Code says if the flashing is rusted, deteriorated, or has holes in it, we have to replace it. So what happens when we actually replace something and then damage something else while we're doing that?
So it specifically depends on how it gets damaged. If it gets damaged because of negligence, then that's not going to be covered under the insurance company. But if it gets damaged because that's the only way to repair the area. So if we're talking about, let's just talk about we've got damage to a ceiling. Well, it's extremely difficult to fix the drywall on a ceiling without damaging the actual side walls a lot of times. So it's very common.
Or the insulation falling down.
Yes, yeah. It's very, very common that that's going to happen. That's not due to negligence. Like that stripping line that's there between the ceiling and the side wall is going to mean that now we're probably going to have to fix the side wall. So it's not negligence. So the question really comes down to what's the reason, what is it that happened in order to cause that additional damage, some of that consequential damages, what is the reason for it? Now, if it's just the negligence of the contractor, then no, the insurance company isn't going to cover it. But if it was reasonable, because that's always the question, is it reasonable? Is it reasonable that it's going to be damaged in the processes of us doing this? So I'll give you an example of that, is that the insurance company will always say, okay, so if we have a homeowner who has a kitchen and the pipes have burst underneath the sink. And now the entire, like we've got water damage all within their sinks. So we have to get all new cabinets on the bottom level. And they've got a cabinet. They've got a countertop.
Mm-hmm.
And so the insurance company is like, well, no, you can take the countertop off and that'll be fine. The countertop's reusable. Well, the odds of being able to pick up that countertop without it breaking are very, very slim to none. So now we're going to write it up that it's all going to be able, it's not going to be able to be picked up without being broken. It's going to all need to be replaced. Now, when a contractor goes to do it, if it does get broken, it's not going to be the negligence of the contractor. It's old. It's been there for a while. Let's say it's been there for 10 years. It's not going to be able to be picked up in one piece, so it gets broken. So that's not going to be the negligence of the contractor. It's going to be that it's reasonable that when you're picking it up, we're picking up the marble piece, and you're trying to pick it up in one piece, and it's squared or whatever it is, or it's an L shape, that it's going to get broken. So those kind of things are reasonable, and that's really what the question is. Is it a reasonable damage that's caused as a result of what we were trying to originally fix?
In your opinion, would you say that most policies have that coverage?
Yeah.
In the state of Florida, how long, we know it's crazy after a hurricane, how long does the insurance company have to produce after the adjuster comes out to the place of business or their home? I guess it could be two different things, but let's go commercial property. After the storm, the adjuster comes out, how long does the insurance company have to produce some type of denial or some type of estimate, emergency funds? And then leading into the next question is, as a contractor and a business owner, how do we expedite that process?
So after the date of loss, and really after you file a claim, so you may have a date of loss. Let's say that you realize that you have damage 3 months later. The hurricane was 3 months before. So whatever you actually file the claim, the insurance company has 90 days to make a coverage decision and pay out that claim.
So is this commercial and residential?
Yes. Yep.
So they have 90 days.
90 days.
How does a business owner expedite the process? What happens if they don't produce anything in 90 days? What would you say to those people?
If the insurance company has not done anything within 90 days of you filing the claim, then you already are, the insurance company's already opened that door to a bad faith claim. So I would say my suggestion in that, really and my suggestion there is to look to getting representation for your claim.
And how would they contact you if they want to get representation?
If they were going to contact the Colucci Law Group, we'll put all of our information. You can go to yourrightsourfight.com. Colucci Law Group is COLUCCI lawgroup.com. And our phone number is 850-542-1111.
Well, we appreciate you answering all these questions. Appreciate your time today.
Thank
I
you.
really love that Candice has a passion for helping the people.
Absolutely.
And we want to bring as much value as we can to you guys.
Perfect.
I hope you guys got something out of this. Thanks for tuning in.
Perfect. Thank you so much, guys. And remember, the more information you have, the more empowered you are. So like, subscribe, follow us, get information, and keep on fighting back.